The prestigious auditorium at Harvard Law School fell into an unmistakable hush as Supreme Court Justice Elena Kagan departed from her prepared remarks and directed an unexpectedly sharp and deeply substantive critique toward Representative Jasmine Crockett. What had begun as a distinguished annual lecture on congressional power and constitutional structure abruptly transformed into one of the most talked-about moments of institutional dialogue in recent memory. The audience, composed of law students, faculty members, practicing attorneys, constitutional scholars, and former clerks, instantly sensed that something unusual was unfolding. This was no longer a conventional academic exchange. It was a direct confrontation between two constitutional thinkers operating from different branches of American government, each deeply invested in the preservation of constitutional legitimacy. The lecture had been designed to examine how power flows between the legislative, executive, and judicial branches in the modern administrative state. Justice Kagan, one of the Supreme Court's most respected intellectual figures, had joined the panel alongside Representative Jasmine Crockett, a freshman member of Congress from Texas, whose national profile had grown rapidly due to her sharp legal reasoning and command of constitutional issues. The pairing itself was unusual. Sitting Supreme Court justices rarely engage in direct dialogue with junior legislators, especially in forums where methodological critiques of the court's jurisprudence might surface. That rarity only heightened the tension as Justice Kagan shifted her posture, paused deliberately, and addressed Crockett directly. Representative Crockett, I need to challenge your earlier characterization of the court's recent Commerce Clause decisions, Justice Kagan stated, her tone calm but unmistakably pointed. You suggested that these rulings reflect political ideology rather than principled constitutional interpretation. But wouldn't a more accurate assessment recognize that Congress itself has increasingly abandoned its constitutional responsibilities by drafting vague, open-ended legislation that delegates fundamental policy decisions to administrative agencies, effectively forcing courts to draw boundaries that elected representatives should have established clearly from the outset? The framing of the question was precise and consequential. Rather than defending judicial outcomes directly, Justice Kagan redirected accountability toward congressional drafting practices. In doing so, she reframed the debate from one about judicial overreach to one about legislative abdication. The implication was clear. If Congress fails to legislate with clarity, courts are inevitably compelled to intervene. This was not merely a rhetorical maneuver. It was a substantive institutional argument rooted in long-standing concerns about delegation, administrative power, and the judiciary's proper role in enforcing constitutional limits. Until that moment, the panel had unfolded with the cordial restraint typical of elite academic forums. Participants had offered measured reflections on separation of powers, regulatory complexity, and institutional friction. Disagreements had been framed cautiously, couched in academic language, and buffered by professional courtesy. That equilibrium shattered when Representative Crockett had earlier responded to a question about recent Supreme Court decisions restricting federal regulatory authority. Her critique was not emotional, partisan, or dismissive. It was methodical, historically grounded, and focused squarely on constitutional methodology. My concern is not about legitimate disagreement over regulatory limits, Crockett had said earlier. It is about the court's inconsistent application of historical standards, the same originalist framework that constrains congressional authority under the Commerce Clause appears to expand judicial authority beyond comparable historical limits. That inconsistency creates the perception that constitutional interpretation is being deployed selectively to achieve preferred outcomes rather than applied uniformly as a principled methodology. That observation, delivered calmly but with unmistakable precision, had cut directly to the heart of one of the most contested debates in modern constitutional law. Crockett was not challenging the outcomes of specific cases alone. She was questioning whether the court's interpretive framework applied historical constraints evenly across institutions. by suggesting that originalism was being used asymmetrically to limit Congress while empowering courts. She raised concerns about legitimacy rather than policy preference. It was precisely the kind of critique that tends to resonate deeply with jurists who take methodological consistency seriously. Justice Kagan, whose own jurisprudence reflects long-standing concern about both judicial overreach and excessive administrative delegation, had clearly taken notice. Her response reframed the issue as one of congressional responsibility, asserting that vague legislation had placed courts in an untenable position. By positioning congressional drafting failures as the root cause of judicial intervention, she effectively challenged Crockett to defend her critique while acknowledging legislative shortcomings. The auditorium fell into complete silence as Crockett prepared to respond. The stakes were unmistakable. Responding effectively to a direct challenge from a sitting Supreme Court justice is daunting under any circumstances. Doing so as a first-term member of Congress in front of one of the world's most sophisticated legal audiences elevated the difficulty exponentially. Even seasoned constitutional scholars in attendance were visibly uncertain how Crockett would navigate the moment. Despite her junior status in Congress, Crockett had already earned a reputation as a serious legal thinker. Before entering politics, she had spent years engaged in constitutional litigation and institutional analysis, developing an approach that emphasized methodological consistency over outcome-driven advocacy. Those who had followed her career closely understood that she was unlikely to respond with defensiveness or deference alone. Still, this was an entirely different arena, one in which institutional hierarchy and intellectual authority weighed heavily. Crockett drew a measured breath, adjusted her notes slightly, and met Justice Kagan's gaze without hesitation. "Justice Kagan," she began, "I genuinely appreciate your substantive challenge. You have identified a legitimate concern about congressional drafting that deserves serious examination. Congress absolutely bears responsibility for the current institutional imbalance, and I have personally advocated for more precise legislative language to reduce the need for expansive regulatory interpretation." The opening was disarming in its sincerity. Rather than deflecting criticism or reframing the issue immediately, Crockett acknowledged the validity of Kagan's point. By conceding congressional responsibility up front, she established credibility and signaled that her critique was not rooted in institutional defensiveness. The effect on the room was immediate. Justice Kagan's expression softened, registering appreciation for the concession. Crockett continued, however, with a careful but decisive pivot. That said, I believe both branches face similar institutional challenges that require mutual recognition rather than unilateral correction. Just as Congress must draft more precise legislation, courts might consider whether selectively applying historical constraints to congressional commerce power, while simultaneously expanding judicial review beyond historical limits, creates an interpretive inconsistency that undermines constitutional coherence. Her tone remained calm, but the substance of her argument was unmistakably firm. Without raising her voice or adopting confrontational language, Crockett reframed the debate from one of blame to one of shared responsibility. She was not rejecting Justice Kagan's critique. She was placing it within a broader framework of institutional symmetry. She then anchored her argument in constitutional history. The historical record demonstrates that the early court exercised extraordinary restraint in invalidating congressional economic judgments. Chief Justice Marshall famously wrote in Gibbons v. Ogden that the power to regulate commerce is complete in itself, may be exercised to its utmost extent, and acknowledges no limitations other than those prescribed in the Constitution. This expansive understanding of congressional authority persisted for more than a century before modern restrictions emerged. By invoking Gibbons, Crockett grounded her critique in foundational precedent rather than contemporary politics. She highlighted that the court itself had evolved significantly beyond founding era limitations on judicial review while now invoking those same historical constraints to limit congressional power. The implication was not accusatory, but it was unavoidable. If historical fidelity is the benchmark, it must apply consistently across institutions. Constraining congressional commerce power based on founding era understanding, she continued, while simultaneously expanding judicial authority beyond comparable historical boundaries, risks generating precisely the methodological inconsistency that fuels legitimacy concerns today. The room remained utterly silent as Crockett delivered her most penetrating observation. Perhaps most importantly, institutional legitimacy requires acknowledging that neither branch has maintained perfect historical fidelity. Congressional drafting has often become excessively broad. Judicial interpretation has also evolved beyond historical parameters. Recognizing this mutual evolution, rather than assigning unilateral responsibility, may help restore the institutional equilibrium both branches seek to preserve. Her conclusion tied the argument together with remarkable clarity. Constitutional legitimacy ultimately depends on principled consistency that transcends desired outcomes. That standard should apply equally to congressional legislation and judicial interpretation. For several seconds after she finished, no one spoke. The transformation was complete. What had initially seemed like a potentially uncomfortable confrontation had become a substantive examination of constitutional methodology conducted with mutual respect. Justice Kagan paused thoughtfully before responding. "You raise a fair point about methodological consistency," she said. "While I continue to believe congressional drafting bears significant responsibility for current imbalances, your observation about selective historical application deserves serious consideration. Courts must remain attentive to how our interpretive approaches affect institutional balance and public confidence." That acknowledgement marked a rare moment of reciprocal engagement across institutional boundaries. Rather than dismissing Crockett's critique or asserting judicial authority, Justice Kagan engaged it on its merits. For the remainder of the panel, the discussion took on a noticeably different tone. Both speakers referenced each other's points, building a dialogue centered on constitutional coherence rather than institutional defense. By the end of the evening, legal scholars in attendance were already describing the exchange as extraordinary. A junior member of Congress had not only held her own against a Supreme Court justice, but had elevated the discussion by reframing it around shared constitutional responsibility. Clips of the exchange spread rapidly across legal and academic platforms. Commentators noted not only the substance of Crockett's argument, but the discipline with which she maintained institutional respect while delivering a principled critique. What made the moment remarkable was not disagreement, but the manner in which disagreement was handled. Crockett acknowledged congressional shortcomings without surrendering her methodological critique. Justice Kagan defended judicial responsibility without dismissing legislative concerns. Together, they demonstrated what constitutional dialogue can look like when principle, rather than power, governs the exchange. The exchange revealed something essential about constitutional governance in a polarized era. Legitimacy is not preserved through institutional triumph or rhetorical dominance. It is preserved through consistency, humility, and a willingness to apply standards evenly, even when doing so limits one's own authority. That lesson, delivered not through theory but through live institutional engagement, is why the Harvard Law audience understood immediately that they had witnessed something rare. What followed was not applause for a winner, but recognition of a process. A process in which constitutional principles were tested, defended, and refined through genuine dialogue. In an age when constitutional debate is often reduced to partisan slogans, that moment stood as a reminder that principled consistency remains the foundation of legitimate governance. And that is why this exchange continues to resonate far beyond the walls of Harvard Law School.